Yes. Hello, my beautiful friends. What an amazing day it is. We have victory upon us. A big one we've been covering here for quite some time. The Fulton County pallets full of ballots case now emerging with a big fat W on it, and we're happy about that. We'll go through the latest. The judge dropped a 68-page order, so we'll hit the highlights of what Judge J.P. Boulay had to say. Of course, remember, this is the battle against the Fulton County fraudsters who were supported because they couldn't handle this on their own by Abby Lowell and Norm Eisen, both of whom just got blown out of the water. So we're going to read through that and indulge just a little bit here. We've earned it. Before we turn our attention to another fraudulent case, in my opinion, the E. Jean Carroll case with the Bergdorfing in the dressing room at Bergdorf's woman, who the jury did not believe actually split that verdict in the civil matter. Well, that's going up on appeal. And apparently she's agreeing to stay the $83 million verdict pending the outcome of SCOTUS. So the president submitted a new brief in that to the Court of Appeals. We'll dive in. And we had a big Judicial Watch victory that dropped over from the D.C. area about the January 6 cases and the body camera footage that they wanted to be covered up. Of course, people have been filing FOIA requests to go after all of these records and take a look at the actual videos, but they said, we can't release this because of privacy unless you pay millions of dollars so that we can go in and redact everybody's faces so that you can't see who was actually there and backtrace all of the individuals who were there actually doing the insurrecting. So we're packed today. We're very glad that you are here and with us. Let's confirm that the tubes are working all across the fruited plain of the interwebs and that we're coming through loud and clear. It looks like things are nice. They're working. That's great news. All right, so that means we can go ahead and get started. So let us do it, shall we? Starting right now. Fulton County loses the big one. The pallets full of ballots cases now emerging with a W. You see, this is the order and the judgment that just came down out of the Northern District of Georgia. And this was the case against Abby Lowell and Norm Eisen and Rob Pitts and the rest of the Fulton County fraudsters after the FBI came in and seized pallets full of ballots to go back through the 2020 election records and peruse and see whether there were any crimes committed therein, you know, like duplicate and triplicate ballots, and so on and so forth. But we'll see here. The judge gave us a lot of details on this thing. He wrote a 68-page decision on this one, and we'll indulge. But here was the judgment that dropped from the court, 5-7, fresh out of the oven today, saying this action having come before this court, the Honorable J.P. Boulay, for consideration of the amended motion for a return of property, right? So what happened, of course, if you're just catching us, is that Rob Pitts and the Fulton fraudsters, they filed a civil action under a rule called 41G. And they know that there's a criminal investigation that's already underway here because that's why we got the search warrant to go in and to seize the ballots. The judge issued 2 search warrants so that they could go seize those. They did. And the fraudsters said, how dare you take our personal property? We can't allow you to do that. So while the criminal case was pending, they went around the criminal investigation, filed a civil action to get the return of their property back. It would be like a murderer who's under investigation for murdering his wife going to sue to get the knife back. To say, well, you should have taken that from my house. Did you get a search warrant? Yeah. Is there indicia that you murdered her? Yeah. Well, what's your problem? Well, I don't want to go to prison, so I'm now suing you to get those records back. I mean, the murder weapon. So the judge says, I've considered everything, and now having denied the motion that was brought forward by Pitts and Abby Lowell and Norm Eisen, is hereby ordered and adjudged that this action be dismissed, dun, 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 in favor of the defendants. Of course, that is the defendants are the United States of America, and those of us who are sick of all of the fraud and the lies and the cover-up of the fraud in the aftermath of the lies. So here's the official order that dropped. It's 68 pages. We'll hit the highlights and the juicy bits, but here's what ultimately came out after this long back and forth. They wanted also to basically do limited discovery. They wanted to go in and ask questions about the DOJ. What were you guys talking about? Who made the criminal referral? Let me see your emails. Let me see your text messages. Who was making these decisions, trying to pierce essentially the ongoing criminal investigation before they were even charged? Now, obviously, if and when they do get charged, they'll have that opportunity. They'll be able to file a motion to suppress and a motion to dismiss the case based on an invalid and illegal search and blah, blah, blah. All of that will come down if and when they get charged, hopefully soon. But now they were trying to get ahead of the game. And the DOJ made some big arguments about the fact that they have no basis for doing this at all. And the judge agreed today. He says, all right, here's what happened. If you forgot, it's been a long haul to get here. But back on January 28th, a glorious day indeed, there was a search warrant that was signed off on by a judge. The FBI went and got 600 boxes of the 2020 records, the pallets full of the ballots, and brought them into their custody. Then afterwards, they went and got the Fulton fraudsters are too dumb to handle this on their own. So they went and got Abby Lowell and Norm Eisen. Now, Norm Eisen, as we know, States United Democracy Center. He runs a bunch of NGOs. And from our read, has been somebody involved in essentially every single collusion hoax, Russia allegation, the impeachment proceedings against President Trump, and so on and so forth. And they got Abby Lowell, the same guy who represented Hunter Biden and many other high-profile Democrats, came in here to help out. So petitioners are Rob Pitts. He actually runs the Board of Commissioners, Board of Elections, Che Alexander, the rest of them, all of the Fulton people came in here, but they needed some assistance because, you know, it's Fannyland and there's only so much they can do out there. So they filed an emergency motion. They said, you have evidence of our criminality. We need it back instantly. After briefing closed, the parties attempted to mediate their dispute. We called that one. That was never going to happen. Saying maybe you guys can come to an agreement about what records can come back and not. But the fraudsters, they wanted not only the physical files back, they also wanted the digital files back. So they said, if you scanned anything, we don't want you to look at that. You can't have any evidence of our crimes. So thereafter, there was a motion for additional evidence. Although the court denied the fraudsters their attempt to get certain additional evidence, the judge said, well, if you can go get it on your own, then I'll review it. And they did. The judge actually ordered them to disclose some certain dates about when the criminal referral was made. If you recall, there was a parallel civil matter that was going on from the Civil Rights Division in the DOJ. And the judge had a little bit of concern that maybe the criminal matter was being used to circumvent the civil matter, which is interesting. It's like an inverse of what's happening here. Of course, here they're trying to use a civil case to get around the criminal case. They're saying, in the DOJ's perspective, they were reversing the argument, saying the DOJ was trying to use a criminal case to get around the civil case, right? It's like, I'm not doing that. That's what you're doing, is what they said. So there was a bunch of briefing. The judge now gives us some background. Now, after considering the submissions and the entirety of the evidence, the judge says, here's what I think the facts are that are pertinent to this analysis. A, the 2020 election in Fulton County occurred. Current litigation also involves 2020 election records, and the FBI seized a bunch of records, and I'm also considering pertinent testimony from an evidentiary hearing, which of course this is federal court, so we didn't get to see any of that live and front and center. In 2020, he tells us, Fulton County voters, remember back during COVID, Fulton County voters could either vote absentee or in person. The pandemic was ripping through the country. Many Fulton voters chose to vote absentee. Yeah. To vote absentee, you had to request an absentee ballot. The secretary, Brad Raffensperger, then sent a blank ballot and 2 return envelopes. One voter, once they filled it out and placed it in the envelopes, the voter would then return the ballot by leaving it in a drop box or mailing it. They were placed in envelopes and they were typically folded, right? So you would say you'd send the ballot out, then you'd fold it up, shove it on the envelope, and that would make some very important creases. You'd be able to see that just like you get something in the mail, something that comes through the mail looks different than something that's fresh off of your printer at home. Voters who did not vote absentee could also vote in person. The voters cast their ballots on voting machines. After a voter made his or her selections using the machine's electronic interface, the machine would then print a filled-in paper ballot with a QR code indicating the voter's selections. And there's some questions about this little QR code because humans can't read a QR code. So what if the machine is encoding something differently in the QR code than the voter ultimately selected. Completed ballots, whether cast in person or absentee, were then electronically counted using the machines. Now, the tabulator machines capture two types of digital records when they scan a ballot. The first record is a cast vote record, which is the actual recording of the selections that is ultimately used to tabulate the results for the election. The second is a picture of the front and back of the ballot, known as the ballot image. Now, ballot images are not ballots and are not used to tabulate the results, but they are often retained as a form of a receipt. Now, in addition to capturing the digital records, the judge writes, tabulator machines also contain a memory card that stores information about the scanned ballots, including the total number of votes cast for each candidate on that particular machine. They have a protective counter, logs the total number of ballots that are recorded on individual machines during the lifetime, similar to how an odometer keeps track of the total miles on your car. At the end of the voting period, poll workers generate tabulator tapes from the machines. A tape documents the number of the counter. Okay, so you're basically taking a picture of what the odometer says on your car to validate, oh, this is when I start putting miles on it. Like you go to the rental car company. What's the odometer when you pick it up? What's the odometer when you drop it off? The total number of ballots above that were scanned during its lifetime and the number of votes cast on that machine for each individual candidate in that specific election. Tapes from the tabulator serve as a paper backup to the memory cards that store the tabs and are not part of the process under the Secretary of State. Those materials are not reported as the final outcome. But under Georgia law, those tapes under the law, must be signed by the poll manager and two poll officer witnesses, and many were not. Now, after the polls closed on Election Day, Fulton County began counting the ballots. This is 2020. 3 separate counts occurred. The first was the original count, began immediately after the polls closed and was completed the following day after the water main break. Fulton County used the machines during the original count to keep track electronically of the votes. After the original count, there was a second count called a risk limiting audit. The purpose of this was to determine whether there was sufficient evidence to overturn the outcome. This was used to validate whether there was confidence in the original result, and these were not certified, but they were also not a precise count. The RLA was just to see confidence. In early December, there was a third count, the recount. Like the original count, the recount utilized the machines again to electronically scan the ballots. Ultimately, the results produced in the recount were certified as the official results, and here is a breakdown of the dates and times. Original count, November 3rd through the 4th. On Election Day, water main breaks in Fulton County. All the news media, oh, what happened? Fanny clogged the toilet or something? That's not good. Then we had the risk limiting audit, a hand count. Then they ran them through the machines again. Now, though a standard risk limiting audit would only include a hand count of a small sample of ballots, all the ballots were counted during 2020 due to the closeness of the race. So he says, now, here's what happened. Now, given the closeness of 2020 and concerns by some that it was not conducted fairly, there were multiple investigations. Following these investigations, many other companies issued reports. He talks about those now. One from Seven Hills Strategies, LLC. So the Georgia State Election Board, and we've seen many amazing people on that board, covered a lot of their testimony here, contracted with Seven Hills to serve as an independent, nonpartisan monitor. In its report, they identified several problems with the election, like extremely sloppy absentee ballot counting processes. While the report acknowledged that the election was not perfect, they noted that there were no indications of dishonesty, fraud, or intentional malfeasance by any Fulton County election officials. At the request of the board and the Georgia General Assembly, the SEB appointed the Performance Review Board. They were tasked with conducting a full investigation. We fast forward. Now we're in 2023. The Fulton County PRB, Performance Review Board, they also issued reports about the elections. In its report, the board summarized previous investigations into 2020 and agreed that there were no indications of fraud, dishonesty, or intentional malfeasance. All they say from the Fulton side, we just made some administrative mistakes, or these were training errors. Nobody did anything intentionally fraudulent. It was all just little oopsie doopsies here and there. The report also stated that the elections conducted in 21 and 22 were not an issue, and they were much smoother than 2020 because they didn't have to steal it from President Trump back then. Then the secretary issued reports, 22, 23, and 24. These reports went into specific complaints. The first report discussed the risk limiting audit. The report recognized that irregularities did occur with the audit and determined, that they were caused by human errors. So even the audit has problems, which it's not supposed to have problems. It's an audit. And issues with the data reporting. The 23 report addressed allegations of mishandled ballots and found, no, nobody violated the law. It's just a little bit of a boo-boo. The final report pertained to alleged problems with ballot images and tabulator tapes. Again, the report found that there were possible violation of the rules that related to the counting process. So they didn't follow the law. Now, the 2020 then led to multiple civil lawsuits. At least 2 of those suits are still pending, and the suits are Allen and Alexander. Both actions were stayed after the FBI came in and seized the records. Now, the Board of Registration and Elections, the BRE, filed actions in court to quash 2 subpoenas by the state election board. Okay, so Fulton, the county, fighting the state election board. SEB wants to get the materials. They say no. On October 6, 25, the SEB, the state entity, issued a new subpoena, which the BRE also sought to quash. They wanted all of the ballots, all of the stubs, all of the signature envelopes, all of the digital files, and more. Superior Court denied the motion to quash, said you have to give it to them, ordered the board to provide the materials once they paid for it. Then the AG of the United States, this was under Pam Bondi, sued in federal court. The Attorney General sued Che Alexander, the clerk, seeking the same materials as the SEB. The AG from the U.S. sought access to the records via a federal statute that says, I'm the AG. 52 U.S. Code says I can inspect election records and go to the custodian and look at those things because federal law says so. On January 5, the clerk filed a motion to dismiss. Then the FBI came in and seized them. Now, the criminal investigation in this case, this is not the criminal prosecution. This is the attempt to get the murder weapon back, came when we had Kurt Olson, the lawyer who was working with Kari Lake in Arizona, the presidentially appointed director of election security. No later than 9:03 a.m. on J5-26, he formally referred the case to the FBI. Thomas C. Albus, the U.S. attorney for Missouri and special attorney to the AG, got the referral on J5. The next day, the FBI opened up an assessment. Shortly thereafter, on J12, special agent Hugh Raymond Evans, who's amazing. Huge fans of Hugh. He's an FBI agent at the Public Corruption Division. He requested this go into a full investigation that was approved on J14. Then, January 19th, he begins to draft his investigative summary. He does some witness interviews. He converted that into a search warrant affidavit on January 22nd. As we know, the search warrant came just days after. Then on January 27, he takes that application, goes to a judge, gets permission to go seize all of it. The court first discusses the search warrant application, then talks to about the execution of the search warrant. Now, as part of the search warrant application, this FBI agent, Hugh Evans, he provided an affidavit to establish probable cause. The affidavit stated that the FBI was investigating irregularities. And he was concerned specifically with missing ballot images. So they scan the paper file and they don't save the image. So you have the paper files and then you have numbers that come out of the machines. And we have questions about whether the machines are spitting out numbers that match the paper ballots. But you can't compare the paper ballot to a scanned digital image to make sure that they reconcile with one another because the scanned images are all deleted. Also, there were duplicate ballots. The example being you have a coffee stain, you're filling out your ballot. Oh, there's a weird coffee stain that looks like Kermit the Frog or something. And you look through all of the ballots and you say, that's weird. 2 people spilled their coffee with Kermit the Frog on there? That's random. How the hell did that happen? No, it's a duplicate. Also, tabulator tapes, pristine ballots, and other issues with the risk limiting audit. The agent also noted a problem with the reported recount numbers. He said in his affidavit, on the day of the deadline to report the recount results, Fulton County reported a recount totaling 511,000 ballots. which was 17,400 ballots fewer than they originally reported. What was the margin of error in 2020 in Georgia? About 11,000, just over that. The following day, Fulton County then said, oh, we found them. We found the total. Now it's 527,000. So somebody pulled them out of the suitcase or whatever. The affidavit then never again mentioned any problem with the number of ballots. While the affidavit only mentioned this in passing, the court does have concerns that the statement was misleading. So maybe the judge, it sounds like, is kind of coming after the FBI agent for saying, well, why'd you have to mention that? Because maybe it was a perfectly explainable reason. So he puts that in a footnote. But then we got the missing images. Now, he did state in his affidavit the FBI was investigating missing ballot images. As noted previously, a ballot image is a digital scan of a voter's completed ballot, and it's automatically created when the ballot goes through the machine. In his affidavit, Evans reported that there were almost 18,000 missing ballot images from the recount. He also said that the direction of Georgia of electors for the Georgia Secretary of State told him that a discrepancy like that would be problematic because you're missing 18,000 votes, okay, that don't match. You can't reconcile those. Evans also provided information that some of the images appeared to have been modified or manipulated as recently as January 11, 2024. The hash data, you can see, just like you go on your Windows and you sort by recently modified, they've got these scanned images and they say 2024. You say, the election was in 2020. Nobody should have touched them. There should be no modifications at all. Although Evans did not fully explain the importance of ballot images or the significance of missing ballot images, he did acknowledge that images, quote, are just duplicates and that it was only the actual ballots that were counted to determine the winner of a given race. We know what the importance is. You have to reconcile the two. He said the concern is less about the images and more about the ballots and the voter count. When the secretary conducted the recount, they did not focus on the images taken by the scanners. They took the actual ballots that were cast and counted them one by one to come up with a total. Evans also further acknowledged that a possible explanation for missing images was that they were stored on a memory card and that it was not uploaded correctly or became corrupt. So there could be some plausible explanation for why we're missing, 17,000 ballots. Now, the judge says there were also indicators of duplicate ballots. In the affidavit, Evans indicated that the FBI was investigating duplicate ballots that were detected by stray marks or other unique markings on the ballot that would allow it to be uniquely identified. That's the Kermit the Frog coffee spill. Evans explained that a witness told him that he discovered duplicate ballots in both the original and the recounts. In addition, the witness also told him that he found new ballots and test ballots in the recount that were not in the original count. In his opinion, the witness, the addition of these duplicate or new ballots did not change the outcome of the election, but could have been an intentional act to make the recount match the original count. Evans also noted that if deliberate, this type of ballot manipulation would be an intentional tabulation of ballots in a false manner in violation of the law. And after detailing these concerns about the dupes, Evans disclosed that the Secretary of State also investigated these issues. And after learning that the duplicate ballots favored Trump, Evans further explained that the Fulton County Director of Registration, which you might want to add in there in the recount if you need to make the numbers match. Anyways, says Evans further explained that the Director of Registration admitted duplication may have occurred, but indicated that if it did, once again, it's human error all the time. Here's more on that Trump favored number. Indeed, the duplicate ballots appeared to favor Trump, says the judge. The witness concluded that what he observed could be intentional, but was not partisan, because by adding the duplicate ballots back, Trump received 10% more than his average in Fulton County, which was 40% instead of 30%. And again, I think the argument in response to that is that you're just trying to make the numbers match. So if you have a discrepancy in the first count, you need to close that gap in the second count. So the duplicate ballots, still could have been inserted to make it reconcile with the first count. The tabulator tapes also were a problem. He also included a discussion of the tabulator tapes in the affidavit. As previously explained, the machines print the tapes out after the polls close at the end of the voting period. Tapes reflect the total number of ballots scanned on the machine, as well as the number of votes cast for each candidate on that machine. The FBI agent Evans explained he spoke with a witness who reported that some tapes from 2020 were not properly signed as required under Georgia law. And this is the law. It impacts the accountability process. The affidavit also referenced an SEB meeting during which Fulton County stated that the tabulator tapes that accounted for 315,000 ballots were not properly signed, which is a huge number of ballots. And that means that the chain of custody is broken, essentially. Nobody can validate how it started or how it ended against Georgia law. According to the affidavit, Brad Raffensperger told the media that he considered this error to be administrative oversight, another one. Everywhere you look, oversight, oversight, oversight. The same witness also told Evans that the tapes should match the number of physical ballots scanned and described the tapes as the holy grail for the final count, right? Because you want to reconcile the two of them. We've got this many ballots, all of the tapes from all of the machines explain exactly how many ballots went through that machine. This number matches that number. We have 315,000 that were not properly vetted and chronicled. So with regard to the tapes, Evans also included several observations from Clay Parikh. Shout out to Clay. We saw him in the Arizona trials. A cybersecurity specialist with experience running security and performance checks on voting equipment and a current special government employee for Trump. After reviewing the tapes that he obtained through an open records request, Parikh suspected that memory cards were removed from some of the machines and inserted into other machines, cross-pollinating them, meaning that certain machines were used to generate final tapes reflecting voting data gathered from several different machines. Now, how is that administrative error? Is there no training that says one card, one machine? You've got somebody who's just, let's put it in here. Let's put it in here and over here. He arrived at this conclusion after determining that closing the tapes from some machines were missing. And of the 138 tapes reviewed, it appeared that 16 machines were utilized to produce tapes for 315,000 ballots. He identified one machine that was used to generate tapes for ballots scanned on 16 machines across 12 different locations. How is that oversight or administrative error? Presumably this occurred by taking the memory cards from 15 different machines and feeding them all into one separate machine that generated a tape reflecting data at the end of the polling from both that machine and the 15 other machines. Based on the proximity of times across the tapes, he also further reported that he believed that someone had manipulated the poll closing and report printed times on the tapes. Sounds like a lot more like intentional fraud. Who did that? Who was doing that? Parikh also reviewed the and how is that administrative error? Who gave that person permission to go get all of the tapes for 15 plus machines and just jam them into each other? Parikh also reviewed the protective counter data reflected on the tapes. Again, protective counters depict the total number of ballots scanned by the machine during the lifetime. He determined that the counter numbers on 5 separate tapes from the same machine were identical, and that for some tapes, the ballots scanned number exceeded the protective counter number. Like they rolled back the odometer. In Parikh's view, this indicated that no ballots were ever actually scanned on these machines at all, but rather the tapes were printed on the machines by inserting a memory card from a different machine and printing a tape based on the foreign memory card's data, right? So that feels like intentional perversion of the numbers, right? Somebody is saying, this is not going to give me the result that I want. So I'm going to take this card, put it in here, have it spit out something on this to show that it matches what I need it to say. The affidavit concluded this would have allowed an opportunity for the tabulation to be tampered with. Another administrative error, I'm sure. Now, after his discussion of Parikh's findings and conclusions, the FBI agent Evans included in the affidavit statement from different witnesses asserting that the tapes were not used to determine the final vote. In fact, this witness reported that the tapes from the original count were not even needed during the recount because the ballots were rescanned using a different machine. According to the witnesses, the ballots were what mattered, which is why we needed to go seize those puppies. Now, we talk about the pristine ballots. The affidavit from the FBI provided that the FBI was investigating the pristine ballots, the freshly printed, right out of the oven, no creased ballots. Evans described these as absentee ballots that have no indications that they were folded or mailed as a typical ballot would be. At the outset, he explained that a board member on the SEB told him there is no reason at all to have a pristine absentee ballot with no folds in it. The affidavit then described claims about a pristine ballot and many more that were made by a poll manager in 2020. The witness stated that during the risk-limiting audit, she saw ballot boxes with broken seals, unfolded ballots, and some stacks of ballots that were located outside the view of security cameras. She described one box in particular that had 110 absentee ballots. According to her, these ballots didn't have folds and they were too clean to actually be real. She said that 107 of those ballots were all identical and they voted for the same candidates in every race, all just printed off in Kinko's. Finally, she thought these ballots had a different texture from the typical ballots as well. Is that another administrative error? Golly, you're gonna have to keep track. The affidavit also mentioned that another witness who assisted with the RLA, the risk limiting audit, likewise remembered that the 107 ballots and said that the selections looked like they had been made with a stamp, not filled out with a pen, not different from one another. The same witness also reported that she saw two individuals re-voting ballots printed on a different kind of paper and was told by the then director of elections for the BRE, these individuals were re-voting because the originals were not accepted by the machine. So you get a ballot in, it's all crumpled up, it can't go into the machine, they re-vote. Some workers take it, they say, okay, this one's coffee stained up, it's got rips and tears in it, we can't put this in the machine, it'll jam the whole thing up. So they re-vote it. They take it, put it on a different paper, saying this is happening a lot. The original was not being accepted. Now, he noted that any duplicated ballots of damaged or unscannable original ballots had to be identified as duplicates. And the affidavit also discussed statements from a current Fulton County commissioner who was a poll worker back in 2020. This witness was assigned to test ballots on tabulator machines to make sure the machines were working accurately. While performing the test, the witness said, she observed stacks of, quote, unsecured test ballots, unattended ballots that had already been cast by voters at early voting locations and the printing of random ballots, even though all the necessary test ballots had already been printed. Like the tests were over. She does the testing. We're done. We don't need them, but they're still out. While Evans detailed the concerns that these witnesses had with pristine ballots, he explained that the Secretary of State's election director did not think it would be feasible for someone to tamper with the absentee ballots due to how many people are in the room, and that it would barely be possible to do anything on a large scale. It's not that large. It's 11,700, 800 votes. Evans also noted that the election director told him there would be pristine absentee ballots in every election because they would generate a pristine ballot after adjudicating a damaged ballot, right? They transfer it over. Agent also noted and reported, the director said, if fraudulent ballots were introduced during the reconciliation process without removing the real ballots, it would be caught. All you would need to do is compare the total number of ballots to the total number of votes, which again, didn't match. The election director also said he was not aware of any discrepancies between the votes and the ballots. And you can't know that because the poll tapes are perverted. And during the risk limiting audit and the final recount, they had to come back and make the numbers match again. Even though the election director opined that it would not be feasible to introduce fictitious ballots on a large scale, he did note that there was no way to determine whether someone substituted fictitious ballots for real ballots during the reconciliation process if the ballots, again, matched. So you can flip the votes, right? You have the total number of ballots at the final count, but the votes flip. So they go from one person to another, even though the numbers stay the same. So the outcome changes, even though the total is the same. Evans also further included a statement from an investigator with the Secretary of State's office indicating that he did not know how a person could inject fraudulent absentee ballots into the count, and that a post-election ballot count performed by Brad Raffensperger and the recount performed by Fulton County, they all matched once they made a match. The affidavit also included statements to the same effect from another witness. This witness, an investigator with Brad Raffensperger's office, also explained that provisional ballots were also all accounted for. Now, the affidavit talking about the RLA also raised issues with the audit conducted by, again, the very same fraudsters. Weird. They investigate themselves, and as usual, they found that they did nothing wrong. As already discussed, the RLA was not an official recount. It's just a tool to verify the results. Evans stated in the affidavit that a witness identified 36 errors within the batch tallies and that these errors included duplicated or misidentified batch entries and incorrect batch entries reflecting 100% of the vote for one candidate. Seems like a pretty anomalous problem. In contrast, Evans also included in the affidavit the statements of one witness who believed that the ballots were all accounted for. One witness says all fake, other witness says all perfect. Evans then also explained in the affidavit that reports from Seven Hills Strategies and the PRB confirmed that there were problems with the RLA. Specifically, the Strategies report stated that there were chain of custody issues, ballots left unattended, unsealed bags being used, auditors not recording seal numbers on ballot bags at all. The PRB likewise found that there were inaccurate batch tallies. So they report there's 100 ballots in this stack, but there's only 70. Evans also disclosed in his affidavit that both parties in their reports concluded that there was no evidence of fraud, dishonesty, or intentional misconduct because who did the recounts? Fulton. They were investigating themselves. Now, Seven Hills Strategy, you might say, was an outside entity, but they're not going to get Fulton fraudsters to admit to dishonesty, fraud, or intentional misconduct. Why would they? They'd go to jail for that. With regard to the election, but rather it's just persistent disorganization, which is not what we heard. We heard this was the most safe, secure, most perfect election in the history of America. And if you had questions about it, you belonged in jail or thrown off the internet and completely castigated as a conspiracy theorist. In Evans' view, the above regularities, if intentionally caused, demonstrate violations of federal law. Section 20701 is a records retention statute. It says every officer shall retain the election records for 22 months, and it's all records. Okay, that's the ballot images and the ballots. More simply, the statute says you have to retain these things, and it's a felony to materially false or fictitious, to willfully deprive them of a fair election. So essentially, the judge says, Evans stated in his affidavit that the seizure of the records could show some of these records were intentionally destroyed or that the tabulation of votes included materially false votes. The final counts ended up the same, but they flipped some of the other votes, either through duplicated scanning of specific ballots or through the interjection of pristine ballots and more. So they executed the search warrant. So that's all of the affidavit. Then the magistrate judge read it, considered the application and said, oh yeah, there's probable cause here. Fraudsters never say that they did it intentionally or with malfeasance. No, I had no idea. I thought there was money in that account. Consequently, the magistrate judge signed the warrant authorizing the seizure. After the warrant was signed, FBI agents went and seized 600 boxes of ballots, pallets full of ballots. Following the seizure, both the Superior Court action and federal court action were stayed because they don't have the files anymore. Evans also explained if these deficiencies were a result of intentional action, it would be a violation of federal law, regardless of whether the failure to retain the records was outcome determinative. Okay, it doesn't matter if Trump actually won or not. You have to retain the records, period. That's the crime. They didn't do that. So the judge actually signed 2 warrants. First authorized the election hub. They went there. They said, actually, the clerk has it. Went back to the judge, said, hey, just to be clear, sign a new warrant. The judge did that twice because they were no longer, the other matters were stayed because the ballots had been seized. So then the court conducted an evidentiary hearing. That was back on March 27th. At the hearing, the Fulton fraudsters, their evidence was primarily focused on what they perceived to be the shortcomings of the affidavit. So Norm Eisen, Abby Lowell, they came skidding in here to make sure that they could help cover all this up. And they said this search warrant is a callous disregard of our constitutional rights as a state, a county body, not a person that has those rights, but a state body. Specifically, they said that Evans omitted material facts from the affidavit. And if they would have told the judge that, she would have never granted the search warrant to begin with. Then they brought in an expert witness, so-called Ryan Macias. This is the same guy. He's like a Democrat election expert witness who they just drag out, and he comes and says whatever they want him to say. And he then provides expert testimony to support their arguments. He said the affidavit is deficient. He opined that the affidavit omitted various innocent explanations for the facts it alleged. He asserted that the pristine absentee ballots that do not have folds are normal, especially for military and overseas voters. And and you don't want to disenfranchise our military members, do you? As to one witness's description of the ballot images that were modified after the date of the election, Macias explained that the Secretary of State's office might have renamed the image files. And that is why it's a modification date later. It's just a simple renaming. He also testified that multiple legitimate reasons could exist for scanning a ballot more than once, and maybe they needed to do that. So his declaration was admitted. His declaration provides that he is, quote, an election technology and security expert who works with this side of the aisle regularly. In addressing the affidavit's discussion of the tab tapes, Macias confirmed that memory cards were in fact taken from some machines and then after Election Day put into different machines to determine the final vote. He explained this was done specifically with the machines used during early voting so that officials did not have to send personnel back to each early voting location after the votes closed. He stated that the memory cards were stored securely until Election Day. They were then used to generate the tab tapes reflecting each memory card's results after the close of voting. He said we had to do that because it's impermissible to begin calculating election results until all the votes had been cast, and that nothing in this is anything that indicates misconduct at all. It's all normal. He also discussed other aspects of the affidavit. He testified that the ballot images in the tapes have no bearing on the election outcome because only the ballots are counted in determining the winner of a given race. He also further testified that the sort of issues identified in the affidavit occur in virtually every election. And so there's no problems here because no election is perfect, which is what Rob Pitts has been saying repeatedly over and over. The facts above give us the context. Now the judge gives us the legal standard. They filed a claim under Rule 41G. It allows the property, aka the murder weapon, to be returned. And the 11th Circuit talks about this as equitable, meaning you have to balance the sides. What is fair? What is equitable between both sides? And saying that if you're going to exercise this type of jurisdiction, it should be exceptional and it should be anomalous. In other words, you should show caution and restraint before you do something like this. Courts are required to apply an exacting test in order to determine whether they should send this property back. And the key question is whether there was callous disregard for their constitutional rights. This is the most important factor. And if callous disregard is not satisfied, there's nothing we can do. Now, although it is the most important factor, they haven't really explained it. Helpful guideposts have been established. What is a callous disregard? The DOJ said it definitely was not because we went and got a search warrant. But the judge says that alone doesn't immunize you from this analysis. Saying the other side says you lacked probable cause and the search warrant, like the execution of the search warrant, was a callous disregard because you didn't tell the truth when you went and got it. They say that the manner was also unreasonable. You interfered with our sovereignty and more. And one of their main arguments is that the statute of limitations had already lapsed. This is from 2020, okay? You can't charge us anymore because too much time has expired. I don't think so. Because if there's a conspiracy crime, then the most recent overt act in furtherance of that conspiracy extends the statute of limitations up until that end. And if they're modifying the files as part of that conspiracy in order to cover up the crimes, I would argue that extends the statute of limitations, and those files were updated in 2024. So petitioners say there was no probable cause. He says the affidavit here was 18 pages long. It identified a bunch of things the FBI was investigating. In petitioner's view, the affidavit failed to sufficiently allege intent, saying that these all could be explained by administrative errors. We're just idiots, and there was no actual intentional, willful type of fraud. They argue that the affidavit didn't identify a single piece of evidence that showed anybody intentionally or willfully, there it is, violated the law. But the court disagrees with them that the affidavit is woefully deficient just because, in their view, allegations of intent are lacking. He says an affidavit need not establish every element of a suspected crime. All it needs to present is a fair probability that evidence of criminal activity will be found once the search occurs. And even if the affidavit did lack probable cause because of a failure to allege intent, your argument from the fraudsters hinges on the idea that a lack of probable cause equates to callous disregard. But there's no authority for that. And so the court is not going to adopt those rules here. And as to the tapes, Evans also reported a witness thought that someone had manipulated the times on the report. There you go, manipulated. Because the poll closing time and the report printed times were too close together. So next, the fraudsters argue that their rights were callously disregarded because you didn't tell the judge everything. Those omissions, had you told them, had you had Ryan Macias come in and explain it to the judge versus an FBI agent, then she would have gotten the full picture and you wouldn't have signed off on the search warrant, whom they contend would not have issued the warrant if she would have known. They focus on omitted facts about the pristine ballots, duplicate ballot images, tabulator tapes, biases of witnesses. So the court will summarize all these. He says, as noted, the affidavit stated that the discovery of the pristine ballots showed that some type of wrongdoing may have occurred. Petitioners say, the fraudsters from Fulton, that the affidavit is incomplete or misleading because pristine ballots are typical. They can occur with military members and other people voting in different methodologies. They also assert the affidavit is misleading because it omitted any reference to Brad Raffensperger's investigation, which said, I already looked into the pristine ballots and I found those were unsubstantiated. So the people, again, behind the fraud, arguably, right? The DOJ is alleging there's a crime here. Something went wrong. We need to go investigate. So asking the person who may be behind the fraud about their opinion of the fraud is always going to result in them saying, of course, there's nothing wrong here. They go on to address this. They say, on the day of the deadline to report the recount, Fulton County reported a recount totaling 511,000 ballots, 17,400 ballots fewer than originally counted. Then they went and found the additional ballots and closed that gap to 527. Now, the Fultoners, they contend that this statement was misleading because 511 was not reported. The recount just hadn't finished yet. It was just merely an interim number until they went and pulled them out of the suitcases. So then, according to them, the next day, 527, that was the final number, and there was never a 511,000 total vote. Now, as to the ballot images and the duplicate ballots, petitioners also argue that they were misleading. They say that they omitted several facts. In 2020, Georgia law did not require the preservation of ballot images. Yes, they did. We saw that aggressively here. Ballot images were required. It's a record. And even I think her name was like Charlene McGowan had testified in both ways. We saw great amicus briefs filed by Kevin Moncla and Jason Frazier and others who confirmed all of this, that saving ballot images was optional for aggregating the results, and that investigators found that scanning some ballots multiple times did not affect election results. And again, that's not the requirement for it to be a crime. Additionally, petitioners assert that ballot images cannot have been the basis for a violation because they're not records. And finally, they claim the affidavit omitted other things that should not have been omitted. Also, that the tabulator tapes argument were misleading. One witness calling these things the Holy Grail. They say that they omitted the fact that the tapes have nothing to do with the final count. And they also say that there were other omitted facts from biases of witnesses. saying that Kurt Olson had been disciplined by the State Bar of Arizona. Well, that's what they do. When you're a good lawyer, like Jeffrey Clark or others, and you go after the truth, they will sanction you and penalize you. But if you are, let's say, a Democrat lawyer who's rigging FISA search warrants, like, I don't know, Kevin Kleinsmith, then they just enable you to keep practicing. So if you're on the right, they strip your license. If you're on the left, it's like, oh, it's okay. Just don't do it again. Okay. Second, petitioners argue that the affidavit failed to include information that one witness was referred to the FBI for sending threatening messages to members of the SEB and Georgia Secretary of State. And they say that the affidavit relied on witnesses who participated in Kerry Lake, who also got rigged and ripped off on this. And he's in a Telegram channel where they talk about election conspiracies. And man, the Proud Boys and the Oath Keepers basically went to prison for that. So in sum, they say all of this means it was reckless in making the omissions. Now, the judge goes through all of that. He says, all right, the court recognizes that the Fulton fraudsters think the affidavit should have contained additional information. However, some of the omissions that they take issue with are not truly omissions at all, but rather appear in the affidavit in a different form. So what is in there, dorks? For instance, they argue that the affidavit omitted important context about duplicate image ballots, but Evans' description of the investigation did include a witness statement saying that the images are just duplicates and that the concern was less about the images and more about the ballots and the voter count. Now, similarly, while they fault the affidavit for omissions as to pristine ballots, the affidavit does have statements from one witness explaining that there would be pristine ballots in every election and offered one explanation for those. And also that they say the affidavit made material omissions about tab tapes. But the document did include a statement that said the original tapes were not used during the recount because the ballots that were scanned utilized a different machine. And the ballots are what matter, which is why we're going to go seize those and have done that. Now, although this court does not entirely agree with their characterization of the omissions, the court does recognize that the affidavit was defective in some respects. For instance, the affidavit stated 511,000 ballots on the day of the deadline, 17,400 short. Then, without further explanation, the following day, 527,000. You pointed out in your briefing, the statement was misleading. Oh, yeah. Why? Because there was a scanner programming error. Oh, no. And Fulton was unable to finish scanning the ballots on time. There's always errors. There's always mistakes. We need more time. Why? The numbers don't match. Okay. We need a reason to get more time. I don't know. Jam something in the scanner. Perfect. Scanner programming error. Oops. It's spitting out the ballots. So then they get more time. They make the numbers match. And I don't think that's defective at all. I think that's very curious. Thus, the 511,000 was an internal report that was used to understand where the county was at as they continued to reach towards the final number. Okay. So the court also agrees that some of the affidavit statements are troubling. For instance, while the affidavit included one witness's statements expressing concern over the modification dates on ballot image files long past the conclusion of 2020, why are they changing the images? It failed to explain that it could have come from simply renaming the file. And so that's presumably what Ryan Macy has testified to. Yeah, it could have come from that, or it could have come from somebody manipulating the file. And I thought it had to do with the SHA, right? I think it's deeper than that. The secure hash algorithm, the SHA of the image. So if you have an image, you take a scan of your driver's license, put it on a computer, run it through an algorithm, it will hash that file, right? It will spit out this gobbledygook that says, this is the secure fingerprint of that scanned digital image. Then you open up that file and you go in there and you're like, oh crap, I just got charged for being under 21, drinking at a bar, and I didn't have my driver's license on me, so they charged me, whatever. And then you go in and you just modify your birth date. You change the year from a 7 to a 1, and you reverse that back down. You save the file, and then you run that same file, which is now changed through that same algorithm. The fingerprint is not going to match. It's going to be different. I'm pretty sure that's what the main argument was. Now, I don't know why that didn't come up at the evidentiary hearing, probably because they didn't have the right people there to explain that. But it's a little different than renaming the file. So again, I think that could be completely innocent, or it could be evidence of fraud. So likewise, the affidavit's inclusion of one witness's description of tabulator tapes as the Holy Grail is also confusing when read in conjunction with another witness statements that the tapes were not even used in the recount. Again, the court agrees that these features within the affidavit are problematic, but nevertheless, the court is cognizant that its task is to assess whether this was a callous disregard. And so thank you, Judge, for explaining what they can and will attack during the criminal case so that the DOJ can have a response to this. Now, as they observed during the evidentiary hearing, the DOJ, the court may think that the affidavit is a B or a B minus or some other grade, but that's not the issue. The issue is whether we have supplied sufficient evidence that their rights were callously disregarded. And in analyzing whether callous disregard exists here, the judge says, the court notes that the affidavit in this case was 18 pages long. It included statements from more than 10 witnesses, all about 2020. While the affidavit referenced witness statements critiquing the election, describing errors and potential wrongdoing, it also included other statements suggesting that the perceived issues did not go beyond benign human error. It just over and over and over and over again. At least 20 times there were contrary information and perspectives presented to the judge. It seems to me, the court, that Evans presented the judge with facts that both hurt and helped him. And while the affidavit was certainly far from perfect, this is not a situation where an officer left out all the facts that might undermine probable cause or where an officer intentionally lied. Ultimately, when examining the totality, including his inclusion of contrary information, the court cannot say that this was so deficient that its shortcomings are callously disregarding your rights. And they never even claimed that Agent Evans lied. Instead, they say he was reckless. And the court notes that they could have called other witnesses who could supply additional context supporting recklessness, and apparently they didn't. So he continues. Now, their argument that the manner in which the search warrant was executed is also a callous disregard. They showed up, they had all of those trucks, tons of FBI agents seizing the pallets. In addition to their arguments about the substance, they also said, well, they disregarded our rights when they executed the warrant. They argued that the manner of the search was unreasonable. It interfered with state sovereignty and ongoing civil proceedings and more. And any of the offenses the affidavit cites have already expired. You can't charge us because you're out of time, which is one of the main defenses in basically American law that we see today. Fauci's coming up on his statute of limitations. James Comey's way over his statute of limitations. Others are just hanging tight, praying charges don't drop, like John Brennan for their statute of limitations. Same thing here. Now, they argue that when respondents seized the records, they did so in violation of the Constitution. They have their duties to secure and to guarantee the secrecy of the ballot, and it infringes on their sovereign rights. But the court disagrees. The records at issue here were from November, and the seizure of those records occurred in January 26. Thus, they didn't interfere with your ability to do anything in 2020. It happened over 5 years ago. They also argued the seizure prevented them from guaranteeing the secrecy of the ballot, but they have presented no evidence that anything is being publicly disclosed. In other words, they have not shown that the secrecy of the ballots is compromised by the seizure at all. This argument is also weakened by the fact that prior to the seizure, the BRE in Fulton in Georgia had already received an order in Superior Court to turn them over. And so they were poised to release copies to the SEB already, saying if another judge said release those records, how is it releasing it to one person, okay, the state election board, but now to the DOJ, that is a callous disregard of their rights. And they have made no argument that the 2020 election records are somehow integral to the state's ability to hold future elections. Indeed, such an argument would be unpersuasive because they allow the destruction of the records in 24 months. Like, you guys would have been ordered to destroy these anyways. So you don't need them for the future. So in sum, the petitioners have not demonstrated how the seizure of these materials occurred 5 years ago, how it infringes on anything. A hearing was held on June 24. The clerk requested back then permission to destroy the records. And the petitioners from Fulton did not present any evidence that voters are concerned that their ballots will be manipulated or misused. And they did not explain whether these purported concerns relate to old ballots or uncast ballots in the future. And so you have not shown anything that they've interfered with, and you're not going to win on that claim either. Now, as previously stated, the judge says there was this ongoing civil proceeding. They said that they were trying to get around a civil proceeding. In other words, they were going to lose in the demand to get these records back in civil court. And so they, in a pretextual fashion, then launched this criminal investigation. But the judge says you can. The court agrees with the DOJ. The government can pursue both civil and criminal proceedings involving the same subject matter. It happens all the time in America. And in other words, a constitutional violation simply doesn't exist just because they're doing both things at the same time. And so I'm not going to say that that is callous disregard of your rights. And it happens all the time. Now, they then suggest that they got a warrant in bad faith after they were struggling in the civil matter. Judge goes back and notes the timeline here. On November 5, 24, 4 years after the election, the state election board issued 2 subpoenas to get the 2020 records. On the date that the responses were due, the BRE filed an action to quash the subpoenas. Over a year after that, the Superior Court held a hearing and a ruling was issued around Christmas the following year. In its order, the Superior Court said that they were required to comply, but the SEB would have to pay $400,000 to do that. Parties were ordered to provide evidence about the costs. Then Superior Court action was going on. They said the subpoenas would not be quashed. Harmeet Dillon came screeching in here, requesting access, saying, we're allowed to do this under the power of the AG. She made an identical request. Then again, they denied the motion to quash. And the timeline, as we've seen before, happened before the motion to dismiss was filed in that matter. And there's no evidence to support the theory that the motion to quash prompted the criminal investigation. In other words, to show that this was pretext. The only outstanding issue is cost right now. They didn't want to pay, come out of pocket $400,000 to just go get the records. They also say that the warrant was in response to a delay in federal court action. But problematically for them, the evidence shows that the criminal referral to the FBI was made before the clerk filed her motion to dismiss, just barely, AM, PM. The fact that Olson referred the matter before the motion to dismiss filed cuts against the contention that any of this was a pretext. So without any other evidence, there is no callous disregard. The court is not convinced that a criminal investigation was created in response to the other hurdles. And finally, they say, well, the statute of limitations, you can't charge us anyways. So give us our murder weapon back because you can't charge us with murder. We got away with it. They say the seizure was unreasonable because it's already expired. Now, they admit, the Fultoners, that the potential expiration of the limitations period does not necessarily negate probable cause. But they say there's no interest in following up on this. Continuing, they assert you should balance all of this. The court says, well, I do recognize this involves a 2020 election, and the statute of limitations for the crimes is 5 years, so expired. The court further recognizes that many parts of the affidavit refer to activity or potential wrongdoing that occurred more than 5 years ago. While this may be true, the court cannot ignore that a witness told Evans that some of the ballot images, oh, there it is, may have been modified as recently as January 11, 2024. That is well within the statutory period. 11th Circuit has said whether a valid SOL exists is not cut and dry. Given the complexities in determining whether an SOL defense is viable, the limited amount of evidence in the record shows some of this is still within the 5 years. The court is not convinced that there is no legitimate interest in this. Nice. In short, while the court understands that they believe the SOL has expired and they think that charges will never be brought, the court finds that the warrant under these circumstances does not give rise to a constitutional claim, let alone anything that would be a callous disregard of your rights. So ultimately, the potential expiration doesn't demonstrate that your rights were violated. So in sum, the Fulton fraudsters, Abby Lowell, Norm Eisen, the expert witness Ryan Macias, all these people brought in on behalf of Rob Pitts and Che Alexander, you have not shown that your rights were callously disregarded, either through the supposed defects in the warrant or through the manner in which the warrant was executed. The court also finds that when considering the cumulative weight of their argument about the defects, they have not demonstrated callous disregard. And so the factors weigh against me stepping in here. Now, although the court could end its analysis here and say that there is no callous disregard, we're going to address the remaining factors. Now, although the Fulton fraudsters bear the burden of establishing that the court should exercise jurisdiction, they did not address the remaining factors, okay? Whether they need the files. The court notes an interest is not enough. Personal interest in the murder weapon is not synonymous with its return. So do they need it? They say they do. They need the ballots to rebut the unfounded attacks on the 2020 election and to fulfill open records requests, which they're not, and to comply with orders from the civil case. But they have failed to identify which documents they need. So without any specificity, there is no articulated need here. And perfect. I'm so glad he put this in here. Even more tellingly, when the FBI seized the records, the Fulton County Director of Registration and Elections stated the FBI could, quote, make paper airplanes with the records for all she cared. So you don't need them at all. They can make little airplanes and just fly them across the hallway. In further considering petitioner's argument that they need the documents to combat election misinformation, the court cannot ignore the fact that they have copies of this. The evidence at the hearing says that they had made copies of these records, and the DOJ has given them copies. So you can validate, right? Their next argument is going to be that any evidence that comes out to show duplicate, triplicate ballots, or that the numbers don't reconcile, the ballots don't reconcile with the other digital files or the digital reports, they're going to say, you guys perverted that evidence. Right? It's like in a murder case, that hair is not mine. You planted that hair. That DNA doesn't match me. You put that in there. The evidence at the hearing established that they has made copies and given them back to you guys. And because you have the copies, you already have the ability to rebut the attacks on 2020 and respond to any elections. You also contend that they need election records to respond to open records requests. Now, you have copies, so you can go do that. And anything else is also speculative because we don't even know if open records requests are coming in. And so we have no way of determining what you're going to get or how you can comply with it. But if something does come in, you can comply. And so lastly, you say, well, the other civil cases. Court, again, finds that argument unavailing. Instead of identifying the documents that are needed for the other civil cases, they simply made a claim that they need all of the documents back, more than 1 million pieces of paper. Way too general. Way too vague. You need specificity. And so in sum, your stated needs for the documents back fails the standard, and we're not giving them to you. And the other cases were asking for different things anyways. The Superior Court civil case was for void ballots, stubs of the ballots, signature envelopes, corresponding digital files, and more. So why do you need all of the records back? Well, we know why they want them back. The other factor is irreparable harm. They say the FBI's retention is going to harm us. Yeah, it's very bad when they have the evidence of your crime for you. Doesn't make it illegal, but it is bad for you. But that's not irreparable harm. For instance, they argue they will be irreparably harmed because they need to show Fulton County that they're in charge of the elections, not the federal government, which they can still run their elections, and that they are facing a constant barrage of criticisms about 2020. Well, run a fair election and nobody will criticize you. In addition to their repeated arguments, they also say they'll suffer injury because they will be unable to verify the chain of custody. Okay, so they're already ceding that argument, as I mentioned. No, the hair on the murder weapon didn't come from me. Some cop put it on there when they transferred it over into evidence. And there's personal identifiable information. The judge says the court does not find any irreparable harm, that they will not be able to address the chain of custody issues. You'll make those arguments once you get charged. And also not convinced that there's any personal information that will be released. The fact that they copied materials does not suggest that they're going to disclose that information to anyone else. They gave you a copy of your files back. Doesn't mean they're going to publish it online. And any factors also weigh against jurisdiction over here. And so you have other remedies. They say the only remedy is the return of our property. But the court is not convinced on that factor either. The 11th Circuit has said that can't weigh that factor in, that you just need the property back. So he relies on a prior case. He says, I'm sympathetic to your arguments that you need the files back. But in this case, the FBI seized the records on J28. They filed this 5/25, 8 days later. And they have not, the respondents had not even analyzed the documents to determine whether they contain any evidence of a crime yet. Okay, so they haven't gone through the ballots yet. Importantly, they have not presented any evidence that they do not intend to ever bring criminal charges. So given that this is recent and that they paused their investigation as soon as this demand for the murder weapon happened, the court is not willing to speculate, at least based on this record, that no criminal action will ever be brought, right? They didn't just come in and like steal everything in your home to say, oh, we're investigating you for a murder and we need your RV because we think the murder happened there. But there was no murder and there was no reason for that. And they just keep your RV. Here the judge is saying, phew, this is all pretty new. So I'm thinking that since they paused the investigation, no charges have come yet because they had to stop. But hopefully coming soon. Now, they speculate that criminal charges will not be brought because the SOL expired. As discussed above, doesn't mean that this is completely barred because of the most recent modification date. If criminal charges are initiated at some point in the future, they could vindicate their rights in the criminal proceeding, the point we've been making since the beginning. They don't want to wait for that to happen. They want to get it back before the charges drop. In short, in light of the early stage of the investigation and the absence of evidence about whether a future proceeding is likely, the court finds this factor weighs slightly against the exercise of jurisdiction. Now, the seizure, he says, was certainly not perfect. However, this court has carefully considered the factors and finds that each factor weighs against exercising jurisdiction. Specifically, they did not establish that their rights were callously disregarded through the lack of probable cause, omissions in the affidavit, or by the manner of the execution of the search warrant. They also failed to show that they have a need for the documents or that they will be irreparably harmed without the documents. They have copies of them. And finally, they failed to demonstrate the absence of an adequate remedy at law. Once they're charged, they can make all of these same claims. And so ultimately, each of these factors weighs against them, and therefore, I'm not exercising jurisdiction here. The court acknowledges that the events leading up to this case are in a variety of ways unprecedented. Yeah, that's what 2020 was. But the test has been in place for nearly 50 years. And so to apply the law differently here because of what this case is about or whose records are at issue would defy our nation's foundational principle that our law applies to all without regard to numbers, wealth, or rank. And as explained in this order, each of the factors, including the first and most important factor, callous disregard, weighs against me stepping in. And so as a result of this, your motion for a return of your property is hereby denied. The clerk is directed to close this case. So ordered, May 6, 2026. Very nice decision from Judge J.P. Boulay. We love to see it. Then today, the actual order dropped, dismissed the claim, and I hope right now all those DOJ prosecutors are just going through those files like it's Christmas morning, baby, and assembling the facts about what happened. We don't want to make up charges, but if there's evidence of a crime, as we know, no one is above the law. So this has been a long battle, my friends. Thank you for sticking through it as we got through this one. We're happy to see this decision come down. And now the criminal case can pick back up in full. We're going to keep our eye on that one as well. Hopefully charges are dropping any day now, but it might take a while. But when they do, we'll be here to cover it. Thank you for subscribing and joining us as we do. All right, now we've got another update in the matter of the E. Jean Carroll case. This one's pretty interesting over here. E. Jean Carroll, the woman who says that she got Bergdorfed at a dressing room at Bergdorf's, now agreeing to stay the delivery of the $83.3 million judgment that the jury said she's entitled to. The president in this filing going up to the Court of Appeals for the Second Circuit, coming up out of New York where the case presided, which was a civil case, Carroll versus Trump, has now submitted this new filing saying we're asking for a stay of the mandate pending Supreme Court review. So Trump is going to be taking this up to the Supreme Court. And he's saying, while we're going there, don't make us pay the $83 million. And what's curious about this is E. Jean Carroll does not oppose this motion, right? Presumably because they don't want to take almost $90 million and then have to give it back if this is all reversed. So her team is just kind of hanging tight and allowing Trump to make his arguments. And they say, you should stay this because we're going up to SCOTUS. And once we get there, we're going to win. So we're not going to have to pay the $83 million period. And you should not enforce the delivery of this big fat monetary fund over to E. Jean Carroll. And if you remember in that civil case where they changed the statute of limitations to enable her to file her complaint, it wasn't a unanimous across the board verdict. As to the claim that Trump, inserted the lower half in the dressing room, they found him not liable for that. So her credibility is not believed as to that claim. Then as to the second claim, the DJ Diddles, grab him by the purse situation, they said, okay, fine, we found in her favor on that one. And it's a civil case. It's not beyond a reasonable doubt. It's more likely than not, 51%. And they found against the president for that reason. Now Trump is appealing the whole thing. They say, all right, Judge, in a dissent from the denial of a rehearing en banc here, 3 judges of this court identified your legal errors, important questions of federal law, and other conflicts with the precedent of the Supreme Court. And so for those reasons, you should stay the mandate. Allow President Trump to present important questions about presidential immunity and the Westfall Act to the Supreme Court. And the Westfall Act is the idea that federal workers, essentially, which the president is one, cannot be liable for certain civil lawsuits when they're doing things within the scope of their duty. I would say it's very similar and analogous to presidential immunity. You might think of it like qualified immunity. Cops acting within the scope of their profession, get into a bad situation. Can you sue them? No, they've got immunity if they're within the scope of their work. So same type of thing, saying we're going to bring this up to the Supreme Court and they're going to grant this. They say there is a reasonable probability that they will accept our claim to address these two. They have granted cert each time based on best research that a president has sought a review that rejects presidential immunity. SCOTUS has also granted cert in an overwhelming number of cases establishing the standard for waiver of structural constitutional immunities that are analogous to presidential immunity, which can't be waived, as well as other cases interpreting the Westfall Act. And second, we think that there is a fair prospect of reversal here. The panel's sole rationale for its immunity waiver, law of the case, will not apply to the Supreme Court. And you guys improperly ignored Trump versus United States back in 2024, which ended Jack Smith's cases and said that we have the 3 buckets of presidential immunity. Absolutely immune, presumptively immune, and not immune. Trump was the president when he was making these statements, these defamatory statements, allegedly, against E. Jean. And moreover, contrary to your finding originally, the prior determination that Trump waived this defense was incorrect. The dissent said it clearly. Trump has a serious claim that the district court conducted the trial in this case in violation of his presidential immunity. The officials and entities involved in distributing the statements, wrote the judge, as well as the context involved direct inquiries to the White House and other comments on matters of public policy. The president can defend himself while in office. Some lady who paints her trees blue, who was basing this whole claim off a Law and Order episode, in my opinion, doesn't get to just lob insults without the president responding. They indicate that he was speaking in an official capacity because she was attacking him in his role. So there was also a fair, in fact, strong prospect that SCOTUS will reverse them. The dissent also noted this. There was no principled justification for holding that AG Bill Barr, his certification decision could be revisited by AG Garland, but Garland's certification decision could not be revisited by Bondi. If it goes one way, it has to go the other way. The dissent also concluded that the panel's decision created a circuit split on how removal is treated under the Westfall Act, which is basically federal worker immunity, because this case either would have come out differently in the DC circuit or it would have come out differently in other circuits if Trump had simply removed the case on the basis of diversity jurisdiction before the U.S. moved to substitute in. And third, there is irreparable harm if you don't stay this. Trump may be immediately required to bear the burdens of proceedings to execute the judgment of $83 million. Allowing these proceedings before the Supreme Court has reviewed the significant legal questions here would eviscerate the immunity. And further, if the execution on the judgment were allowed, it is very unlikely that any money could be recovered because Carroll has publicly said she plans to give away any money that she gets from the lawsuit. SCOTUS has repeatedly found irreparable harm, like here, where money distributed pending an appeal is unlikely to be recovered. And fourth, the equities also strongly favor a stay of the mandate. Trump will suffer irreparable harm if a stay is not granted by being deprived of immunity. In not opposing this motion, Carroll asked the following statement be included in her position. She said, without waiver as to or addressing any of the arguments in the motion, the appellee does not oppose the motion on the condition that they increase the bond to $7,400,000 to account for any post-judgment interest that would accrue during any proceedings up through SCOTUS. So the court should stay the mandate. These are vital questions, and Carroll does not even oppose this. So we'll just pay a little bit more money and then continue to progress this up through SCOTUS. Now, if we do go to SCOTUS, we must show that there is a good cause for a stay. We need to demonstrate there's reasonable probability and more. Each one of these factors weighs in our favor, says Trump. We're going to address two issues: whether the president's absolute immunity from civil claims based on official acts can be waived. Trump says it can't, and at least without an explicit, unequivocal renunciation, which he didn't do, and whether the U.S. timely filed and did not waive a Westfall Act certification to say that he was an employee who's protected. So based on these issues, the United States is also going to go up to SCOTUS on the Westfall Act. The Supreme Court is likely to grant these petitions. These are important questions of federal law. Cert is warranted when a U.S. Court of Appeals has entered a decision that is in conflict with another circuit and when there is an important unsettled area of law. All three criteria are satisfied here. There are important questions also being raised here. First, what about immunity? SCOTUS has never held that this is waivable. The panel said that a 2023 interlocutory ruling that immunity is waivable is a matter of first impression. But we had another decision from SCOTUS, and so they were relying on incorrect cases. Past practices also demonstrate that there is more than a reasonable probability that they're going to review this. In fact, the Supreme Court, according to best research, has granted cert every time, anytime a president has sought review of a lower court decision that rejects this, citing a bunch of cases. So given this long tradition in reviewing this, it's more than reasonably probable that they'll want to hear this case as well. They've granted a large number of cases that are similar to this. For example, here's a case, here's another case, and they always want to clarify these waivers. Now, the panel at this Court of Appeals also erroneously decided that Trump and the United States waived certain things that they didn't do. They said that Pam Bondi's certification was untimely. It wasn't. Under the Westfall Act, the panel wrongly stated that the AG may move for substitution at any time, but only before the case goes to trial. But the need to protect federal employees does not disappear and actually may become more urgent once a trial has occurred. And so they can make those claims after that time as well. This is all confirmed by precedent. The Supreme Court has repeatedly granted review on the Westfall Act. The panel's decision, if allowed to stand, would irreparably weaken presidential immunity and the presidency himself, because immunity protects the presidency, not an individual. It's a constitutional argument. And you're going to get reversed. The second factor also considers whether there is a fair prospect that this will be reversed. Factor is satisfied when the underlying cases are important and difficult. Here, your decision committed a series of fundamental errors. A full accounting of these errors must await briefing before SCOTUS, but Trump highlights a series of independently sufficient bases to do so. The judges in the panel strongly state that you guys didn't even analyze presidential immunity. You relied exclusively on the law of the case doctrine to dismiss Trump's entire claim. But that doesn't bind the Supreme Court. There's key precedent called Nixon versus Fitzgerald, which recognized absolute immunity from civil claims based on official acts. And that carries over to Trump. In Trump, the other Supreme Court case, they said immunity is required to safeguard independence and the functioning of the executive branch. It ensures the president is not chilled from acting as the president. And the argument in this case falls squarely within the line of these other immunity cases. And the Supreme Court has said a lot of types of immunity are not waivable at all because it protects the institution, not the person. Now, two claims that Carroll made, which she said that were defamatory, are clearly protected. The president possesses the power to speak to his fellow citizens and on their behalf. Most communications are probably within the outer perimeter of his official responsibilities. Those acts played a pivotal role in the unlawful outcome. Trump was acting officially. At the trial, counsel for Carroll emphasized the official character of the statements, saying these statements indicate the jury was invited to scrutinize and punish official acts of the president, which they can't do. He's immune. Contrary to the finding, the prior determination that Trump waived those defenses is also incorrect. He consistently raised his defense repeatedly. 3 dissenting judges agreed with that. And what he was doing was making a statement defending his fitness for office and bolstering public confidence in his leadership. All of it was issued through White House channels during White House press events, are plainly official acts. Ruling otherwise irreparably damages the president. I guess the president can never respond to any claims by some crazy lady. Accordingly, there is at least a fair prospect the Supreme Court will reverse. And the Westfall Act and removal and protections for federal officers, they said it could only happen before trial. But they say there is no time limitation. You can still invoke these things after the fact. This erroneous holding, saying it only comes at a certain time, is creating a circuit split. This would have happened differently in a different court. And so the Supreme Court is likely to have to reconcile the difference here. And they said that AG Barr's certification could be revisited by Garland, but Garland's certification decision could not be revisited by Bondi. So that seems pretty arbitrary and capricious and completely unfair. So we think that they will reverse. And there's also, in the third factor, irreparable harm. She has publicly and repeatedly promised to give away any money that she gets. Once grants are distributed and spent, the funds almost certainly will not be recoverable. SCOTUS has found irreparable harm when they're unlikely to recover the funds. So Trump will suffer this harm if you don't grant a stay here. Issuing a mandate to force the payment will eviscerate the immunity. And so this is not a close case. The court need not balance the equities. But if you want to go through that analysis, they favor Trump. Carroll will not suffer prejudice by staying this. If a stay is granted, she will be able to collect from the petitioner all money from the judgment if the panel's erroneous ruling is somehow upheld, which it should not be. And so stay this until we go up and through SCOTUS. So we're asking you to stay the mandate until the Supreme Court's final disposition until all resolution of all proceedings. Carroll does not oppose this motion. If the court were to deny this request, which it shouldn't, Trump should request that the court grant an administrative day for at least 14 days to allow a reasonable time to go up to SCOTUS and seek a stay over there. So this one continues to march through, signed by Justin D. Smith, up to the Second Circuit Court of Appeals. And it's interesting that Carroll doesn't, she's okay not having that money right now, presumably because she realizes that if she loses this thing, then she has potentially the liability of $83 million, which she doesn't want to get ensnared in. So going up to SCOTUS, and I think the presidential immunity argument, which obliterated both Jack Smith's cases, is going to come back and be in favor of the president. We're going to keep our eye on this one. Thank you for subscribing and joining as we do. All right, one more update today, my friends. And then we'll hear from you. And this one is a good one. Big victory in the January 6th Bodycam battle. Judicial Watch securing this one for us, saying that the court in D.C. rejects now a bid to hide the J6 Bodycam footage. And there is a lot of footage that they do not want coming out here. They announced that in D.C., a judge said that the Metro Police Department cannot broadly blur and censor body-worn camera footage from back on J6. They had previously claimed, the police, that these redactions were necessary to protect the personal privacy of all of the cops. They wanted $1.5 million in order to go through every piece of video and blur out the officers' faces. Judge who signed off on this is Judge Veronica Sanchez. She's this woman right here. A Joe Biden judge said, release the footage. We're happy to see it. Here's what came down courtesy of Sanchez, Martinez, Sanchez, Veronica Sanchez. Here's the decision from the Superior Court of the District of Columbia, the Civil Division, not federal court. Judicial Watch sued the District of Columbia. She explains, all right, before the court here is this matter. We're asking whether personal privacy redactions of non-law enforcement personnel's faces and voices are appropriate as they relate to the body cameras coming from footage from the Metro PD. Now, the defense, the DC police, they no longer argue that a full exemption under the DC code is warranted, but they say, okay, if we have to give things up, then we have to redact it. They say there are personal privacy interests of non-law enforcement individuals captured on the camera. Now, back on June 1, 25, a different judge ordered the parties to provide briefings on this issue. And having considered these briefings, the oral arguments and applicable law, the court finds that the privacy interest of these other people, non-law enforcement people, do not outweigh the public interest in the disclosure. Here's some more. 7 months after the events on J6, plaintiff, Judicial Watch, made 2 requests under DC FOIA for all body-worn camera footage from officers responding on J6. The first request, August 5, 21, was for the specific body-worn camera of Officer Michael Fanoni. You remember him. Let's grab a photo of him because how could we forget? Michael Fanoni. Remember that name? That fella right there who pounded the table and screamed at everybody and is, I think, a little bit needing anger management. Remember him? He's also the same guy who got into it with Ivan Raiklin. Ivan Raiklin was, hi, Mr. Fanone. Hi, how you doing? Fanone, going nuts. So that's that guy, 45 years old. They were trying to go get his information. On August 6th, the Metro Police denied the request on the basis that the body-worn camera had been identified as related to an ongoing criminal investigation. Then on August 6, 21, plaintiff made a second request. The second request sought the body cameras of all officers present on J6. On August 9th, they again denied the second request for the same reason. Now, they appealed that decision via the FOIA portal, and that appeal was denied. Plaintiffs filed a complaint seeking production of all non-exempt public records. The district filed an answer. Then the DC people filed a motion for summary judgment, then filed a motion to stay. They said discovery is rarely appropriate here. More filings here in 2024 and more. Now, Judicial Watch argued the briefing schedule should be stayed until we get full discovery, and back and forth briefings on those. Now, prior to the court issuing a ruling, plaintiff then filed a notice to the court, memorializing on the docket the change in circumstances about criminal events. KGA 29, 2025. There are no more ongoing criminal investigations, okay? Trump pardoned everybody. You're not charging anybody. Then Trump had commuted the sentences and more, full complete pardons across the board. The district then filed its own notice, said, yeah, okay, we got the pardons coming in. So they're like, crap, we have to give these things up now. The district indicated in its notice that as to the first request, it would produce 2 responsive videos after personal privacy redactions. The district also noted that it would withdraw its position about the FOIA exemptions because it's not interfering with law enforcement anymore. But then they changed their argument. They said, well, now it's about privacy rights, and said that the burden on the government of redacting and producing such a large amount of this is substantial. In its filing, the district also indicated that it did not concede the production of unaltered camera footage in this case was proper, saying that it may capture certain personnel, namely third parties, who maintain cognizable privacy interest in their names, images, and likeness, and that disclosure would not serve the public interest or shed light on the performance of its duties. So given the change in circumstance, the court denied the pending motions without prejudice, asked for additional briefing on the privacy matter. While the court notes that privacy redactions are appropriate under both code sections, they rely on legal DC codes, which are a lower threshold. So they filed additional briefs, more briefs, more briefs. They heard oral arguments back on J826. So, been going on for a while. Thank you, Judicial Watch. The District of Columbia, FOIA, provides any person has a right to access public records. Because many of these provisions are in parallel with federal courts, we analyze them similarly. Public bodies are required to disclose records responsive to the request, except those protected by one of the exemptions. And goes through some more case law here. Very verbose. At issue in this matter are 2 exemptions raised by the district. One is about faces and voices. The first provision allows an exemption for personal information if it would create an unwarranted invasion of privacy. The second provision permits exemption where the production of law enforcement records would constitute an unwarranted invasion of personal privacy. Both sections are protecting unwarranted. Thus, the preliminary question is there a personal privacy interest within the records at all? Where there is a privacy interest greater than de minimis, like basically, nothing, very minimal, the court must balance the interest of the public interest in disclosure versus the invasion of privacy. The balancing analysis for determining this is because we want our citizens to know what their government is up to. The exemption controls if the personal privacy interest outweighs the public interest in disclosure. We got it. Now, DC contends that the individuals in the camera footage do have substantial, it's not de minimis, and it must be protected. Alternatively, they say, even if the court finds that they have a de minimis privacy interest, the balancing test, the court must apply favors redactions because the public interest is minimal and doesn't outweigh the privacy interest. So it is substantial, but if you think it is not substantial, it's low, well, the public's rights are even lower than that. Now, Judicial Watch says individuals captured on the cameras have no privacy interest that warrants their faces and voices being redacted. They argue that the events of J6 were a public event on public property. And they reference these other cases that say, yeah, you don't have a privacy interest in body camera footage that took place in a public place. In the alternative, they say, even if the non-law enforcement individuals have a privacy interest, then the public interest outweighs that. So the district says, she writes, we rely on the Court of Appeals cases to support, DC does, to support privacy interests are strong in body camera. They cite a case law that says it's strong. They rely on these cases and go through other matters. The district says, even if it won't lead to criminal prosecution, it could lead to reputational harm, and there are other matters. Now, finally, the court disagrees that the privacy interest is significant or substantial in this matter. First, the district has amalgamated under its argument all individuals captured in the body-worn camera footage that are not law enforcement personnel. As stated by DC, this group includes rioter, bystander, journalist, or someone else. This group of individuals do not have the same privacy interest. A journalist present at the events that unfolded on J6 does not have a strong privacy interest. In fact, a journalist present reporting on the events likely has no privacy interest. It is difficult for this court to determine with any degree of precision the actual invasion of privacy that would occur from the release of this if it captures a reporter. The government says that individuals shown in the camera are more difficult to distinguish than bystanders at a fatal shooting. However, that comparison is not analogous to J6, when the lack of privacy redactions very well may differentiate the behavior and the conduct of non-law enforcement individuals. The court notes that there well may be individuals captured on camera who have more significant interest in not being associated, but the court finds that without specificity to those people and circumstances, those interests are uncertain and speculative. And so the privacy interest there would be a little bit more than de minimis for the reasons I've explained. Now, the circumstances leading up to this event included a large public televised event on the National Mall. Individuals were gathered in a public arena. The crowd marched to the Capitol. Members of Congress were partaking in the certification of the results. It is well established in the public domain. Many participants in J6 events themselves were filming and posting videos. Unlike other cases, the individuals in this case were not on wholly private property. The individuals were both inside the restricted interior, many invited in, of the U.S. Capitol complex and outside the grounds. This is different from the public thoroughfare. And the Capitol is a non-public forum. The Supreme Court and lower courts have held that restrictions inside the Capitol grounds are permissible. And so the surrounding grounds have less restrictive regulations for public gatherings than the interior. So the privacy interest is then attenuated by the extent of the dissemination. Individuals on the camera could not reasonably expect their privacy to be protected. A person's privacy interest is greater in the release of images and footage that were taken without their knowing consent. Now, even though they may not have consented to being in the body cams, they certainly had reason to believe that many law enforcement were wearing those, and they were being recorded. There were simultaneous media images from both inside the Capitol and the complex that were being streamed and broadcast all over the place. While they may not have knowingly consented, they had reason to know that they were being recorded. Many of the individuals in the camera footage have already had sentences commuted or pardoned. DC says being associated with these events could lead to reputational harm. They cite several examples. Plaintiff doesn't dispute that claim. But the focus on the stigma is related to the public nature of these events. And a pardon limited that stigma. The court cannot find that there is no privacy interest. The court finds that there was a little bit more than de minimis. This triggers a balancing analysis, and so we have to compare it against the public rights. Here's what she says about public interest. Now, in this matter, plaintiff has argued a high public interest in this, saying what happened on the grounds of the Capitol complex is of high interest to everybody and the country at large. DC says this should weigh towards privacy and not to the public, but the court does not agree. FOIA is designed to pierce the veil of administrative secrecy and to open agency action to the light of public scrutiny. Thank you. The policy behind disclosure focuses on the citizens' rights to be informed about what their government is up to. The events of J6 have been the topic of much debate, much discussion, and scrutiny in the public consciousness by not just the residents of DC, but also the nation. Body-worn camera footage of the events at the Capitol could contribute significantly to the public's understanding of the events that day and the police action. In balancing these rights, which are privacy rights, are a little bit more de minimis, the public interest outweighs the privacy rights, signed by the judge, saying it is now ordered that the faces and voices of individuals captured by the body cams on J6 are not exempt from disclosure. So release the videos. Now, this is interesting because from her perspective, it's probably, she's a Biden appointee, probably like, I want people to see what really happened on that day. And I want everybody in there to be identified. And this will bring accountability to those who may not have been identified. Maybe the, sedition hunters or whatever will find some more people, whatever. So she may be thinking that it's going to actually incriminate more people who were not already subject to the wrath of J6 and the Biden attacks on large portions of America. From our perspective, we've got a lot of questions about 250 so-called FBI agents that Kash Patel admitted were there to do riot control. All the Homeland Security agents that were there that were never discussed in the trials because the judges said that they were not relevant in the Proud Boys and the Oath Keepers cases. Any other CIA assets, any other Ray Eppses who were floating around the scene, who were instigating these insurgencies all across the Capitol building, and more cops who are tapping other cops on the shoulder and saying, come on into the building. Or like that one cop who said, man, they set us up. They pulled everybody off of the Capitol, sent them all over to the RNC and the DNC for the pipe bomb, didn't take the calls of Capitol Hill Chief of Police Stephen Sund. He wrote about it in his book when he was calling for backup and support. We'd like to see more of that imagery so that we can connect the dots, because obviously they never did that. So nice order from a Biden judge. Veronica Sanchez saying release the tapes, and Judicial Watch celebrating this accordingly. And we're happy about that. So hopefully it's on full display for all to see. And then the interwebs can do their thing and piece this whole fake hoax insurrection together so that the truth can come out, because this was one of the tentpole hoaxes that they unleashed after Trump's first term to try to take him out. Obviously, that has now failed, and now justice is coming. We're going to keep our eye on this one. Thank you to Judicial Watch for the great job, and we'll see you back here on the next one. All right, friends, what a lovely stream it has been. If you're just getting here, we talked about the major win out of Fulton County today, the pallets full of ballots case, now dismissed. So Abby Lowell, Norm Eisen, and the rest of the Fulton fraudsters who wanted to cover up what they did in 2020 will no longer be able to do that. The ballots are over in DOJ FBI possession, and hopefully they are rummaging through them legally and professionally right now. We then talked about E. Jean Carroll. She's agreeing to stay the $83 million verdict, so saying that Trump does not have to pay that right now pending the outcome of the Supreme Court. And Judicial Watch scored a big victory, showing us that body cameras can be released without redactions on everybody else there, because we think that there were a lot of undercover individuals there who were dressed up in MAGA gear and instigating the so-called insurrection. But now, my friends, it is time to hear from you. Thank you for being here. Thank you for subscribing. Thanks for liking this video if you're heading out of here. I think I saw some great donos come in and some good friends with some fun stuff to say. Let's see what we got. Hey, Bill Tong is here. Hey, Just John Doe, what's up? We got Membos coming in. We had a great members only stream. Viva sent us a raid today. Shout out. Hey, it's Oprah. Oprah's also here. You get a subpoena. You get a subpoena. That's the DOJ. You get a subpoena. You get a subpoena. Yeah, maybe, I don't know if we want Oprah in the DOJ, but maybe somebody with that same energy over there. Hey, thank you. Todd Blanche has a little Oprah energy, I think. Hey, Viva. What's up, Viva, man? Thank you for the raid. Shout out to our Viva friends coming over from Rumble. We appreciate you. And hopefully you stick around. Thank you, Viva. Psychological Projectionist says, seems the DNC leaders believe Trump's denial claims. Denial? That's not a river in Egypt, right? Seems like the DNC leaders believe Trump's denial Nile claims. I'm going to have to sleep on that one. Psychological projectionist. Thank you for the dono. Shout out. That one's coming in over from Europe. Da Hook, what's up? Hey, dadgum Tim Burchett was on Rogan today talking about dadgum aliens. I saw that. I didn't listen to it yet, but I plan on it. I think I saw a clip. He said he was going to talk to one of Hegseth's people today, and they were going to release some information about the aliens. I saw some other headline, too, that they were saying that pastors and religious people should be preparing their congregants for news of the aliens or something. All right. Dadgum Tim Burchett. Man, we like him. Tim Burchett. Hey, Rick D. State Rep in Tennessee, Justin Pearson, decided that state troopers were a good target to go after today because he didn't like the vote. Yeah, I think he was screaming F-bombs, all sorts of stuff. Tennessee passed some bill eliminating racist districts, and some maniac went nuts over there. Thank you, Rick D. Guy's name is Justin Pearson. Thank you, Rick D. Yeah, I was scrolling through that. Hadn't watched that one. Hey, this old guy. Good to see you, this old guy. Yeah, it's been a while. Hey, watchers, I'm alive and well. Haven't been able to be around for a while due to work schedules that were unavoidably requiring my complete attention. But life is good, and I'll be back here in the near future complaining about Democrat BS. Just saying. And thank you for your attention to this matter, this old guy. Yeah, I'm glad you're doing well. You know, work is good. Work is priority. Work is good. We'll be here when you come back and when you're ready, and you'll have every single thing accomplished, and you'll be feeling nice and solid. And then this show will be that much more enjoyable. This old guy, thanks for checking in. I did notice that you're gone. So thanks for the update, and thanks for the nice dono. Hey, Biology always wins. What's up? Bringing in 5 new membos. Thank you, Biology. Look who's coming in. Carla Martin, what's up? CKO Lacia in the house. We got Dan Martin, welcome. Yakub's Fave YouTube in the house, and T-Jaws 1310 in the house. All gifted membos, courtesy of Biology always wins. Great to have you here. We had a beautiful members only stream this morning. And tomorrow on the member stream, we should have the lectern guy who's coming over to join us. And we're excited to talk to him. We've got some good stuff to get into with him, no doubt. Hey, who else but John is here? Hey, what's up, John? Just John Doe, XOXO. How did GOP get suckered into accepting count of the ballots matching count of total images? We should be able to match every ballot with that ballot image 1 for 1 and identify ballots don't have images and images that don't have ballots. Yeah, I agree with that. I mean, like literally, they should be 1 to 1. Like that's how the system works. So if nothing reconciles there, I would completely agree with that. Like that's a big problem, which is why I think that there were some concerns that they deleted the images and then modified the images and then maybe inserted the ballots. Like if images were deleted, then you can't reconcile the both. Okay, so like what if somebody votes Trump, Trump, Trump in the physical ballot, somebody pulls those physical ballots, Trump, 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 swaps them for Biden ballots, deletes the images so you can't reconcile those. Then the recounts all show, oh yeah, Biden won. But that doesn't match the voter. And the ballots are basically anonymous, right? They're not tied to the specific voter. So yeah, there's a lot of problems with that. And then you need a chain of custody. What machines did they come through? Who was handling the machines? What did the machine say at the start? What did the machine say at the end? So you can validate whether one machine in one precinct got like 10 million ballots, like 3 times or whatever the number is of what should be coming through. You can't check. Everything is cross-pollinated. It's like in a DUI case, if like you're mixing blood samples, everybody's DUI is getting dismissed, right? Because you can't mix blood samples. It's like one person, one sample. If there's a question about the chain of custody from where that sample goes from this person, then you have, I don't know what the sample is because somebody may have left it in their car. Somebody may have, put it in the microwave or something, and it might be perverted. So it's no longer reliable. And that's a huge problem that we're trying to unpack here together. And it's always, always administrative error, human mistake, oversight. It's never maliciousness. It's never intentionality. But couldn't you make the argument that if you just keep screwing stuff up over and over and over again, that is not in compliance with the law? Literally, Georgia says you have to keep these things. They don't. Governor Kemp said that there were like 34 problems. Then we got Vic Reynolds, who said you got to be a team player, to Senator Perdue. Then they appointed him to be a judge. Sort of feels like there's a cover-up going on. And fortunately, we got a very good decision today. So I'm happy that that came down the way that it did. Hey, King of Biltong, what's up? Turn up the flavor with Peri Peri Biltong. It's mild heat, big flavor, 50% protein to keep you going. Try the full Peri Peri range, BiltongUSA.com, code Robert, and you'll have 10% off on your meats. Thank you, King of Biltong. Hey, biology, 5 more membos coming in. Amazing. We'll see you tomorrow, 10 a.m. Eastern. What's going on? Glyph, Diva, the Divine Light, welcome. We got Sam Watson, the real Chris P. Bacon in the house, and Melissa Reidner. Welcome aboard. Biology always wins. It's true. Thank you for that, Biology. Thanks for bringing in 5 new membos. And hey, check out Viva Neuro D. Thank you, Neuro. Tonight, 7 p.m. Eastern, 5 minutes from now, check out Viva and Lord Buckley go to the movies. What's going on? They're going to watch Citizen Kane. Viva and Lord Buckley watch the greatest movie of all time, Citizen Kane. Orson Welles' groundbreaking 1941 masterpiece follows the meteoric rise and lonely fall of media tycoon Charles Foster Kane. Never saw it. Maybe we'll have to watch it with Viva tonight. So they're streaming it over on Viva's channel. Well, that's fun. So check that out. Probably over on Rumble at Viva Fry on Rumble. So look him up and go check that out. Hey, Lone Wolf Fan Club. What's up, Lone Wolf Fan Club? Fan Cub. Lone Wolf Fan Cub in the house. Thanks for rating us, Lone Wolf. Stick around, Lone Wolf friends, and we'll see you back here soon. Hey, Old Coach Crane. What's up, Old Coach? Maybe Biden judge is on the level. Yeah, I don't know. I think she probably has a different motive for releasing it. She probably wants, like, everybody to be seen so that they can, be on the record. Like, she probably has a negative motive against the J6ers, whereas we want transparency for the real non-J6ers, right? The feds who were in the chat on that day. So, but I think, accountability serves us. Like, a lot of the people have already had their lives destroyed. Many of them went to prison, and now we get to see the actual truth of who is really there. Hey, Jim tells you, awesome. We'll send you over to Jim's channel this evening. If you're looking forward to that, stick around on YouTube. It will auto-magically transfer you over there. And the taco vendor. What's up, the taco vendor? Woot, woot. This makes 12 full months. Happy 1-year anniversary to us, the taco vendor. Man, we love tacos here. We do. They're good. Yeah. Not so much pupusas, though. Tacos, though, are still okay. But hey, taco vendor, thanks for being here for so long. We really appreciate that. 12 months as a member. We've seen a lot of stuff together and had some good times. Hopefully many more to come. And all right, Jim tells you Raid has now been connected. Dun, 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 dun. Amazing. Let's see what else we got. Any comments over on locals? And then we'll wrap it up on the night, my friends. It's been a beautiful Thursday. You know what that means. Tomorrow is a Friday. We're looking forward to it. See what else we got percolating over here. Neuro D, thank you for linking us up over on the X. You rock. You can join us as a membo at watchingthewatchers.locals.com or on YouTube. Click the membo button. And we'll see you tomorrow morning. And LZ. Hey, LZ, bless you, Robert, for your diligent efforts reading all these court documents. I hope your jawbone doesn't hurt after that. I got like allergies going on. It's like my pollen apocalypse is what AI said is happening in DC right now. So I've been sniffling a lot because I got the pollen apocalypse going on. So it's not my jaw, it's my inside of my head. Quick question. But thank you, LZ. It was a lot of reading today. Does the DOJ, and it's business. We have to attend to it. There's no excuse about it. Does the DOJ and FBI need to suspend all their analysis of the ballots until the court case completes? Thanks again for all you do. Well, thank you, LZ. Thank you for being a member on Locals and for the nice comment. They had suspended. Yeah, so they had suspended it, right? So once they filed the motion for the return of their property. The judge says, okay, kind of pause everything. You've got this evidence. This evidence is in question. Stop going through the 600 boxes of ballots. Now that that case has been dismissed, it's just like any other criminal case. So presumably they're going back through the evidence right now. So now, no, they can unsuspend their analysis. This court case is over. Like the judge ordered it dismissed. And here is the docket, just to confirm that for you. Yep, they mailed it. Order on the motion to unseal the document. Clerk's judgment. Denied. Court is directed to close this case. There it is, baby. So now all of the analysis can pick back up, and we'll be excited to see exactly what that analysis returns. Hey, what's going on? Hey, when you mentioned you were doing the home birth yesterday and your first concern was tarps, how many tarps, what quantity, and what size? Yeah, the soda in my mouth was promptly launched out of my nose. You're absolutely hilarious, Rob. Thank you for your candor and humor while educating. I know it's tarps or, you know, like, what are they called? The rain outfits? Parkas or something? You are hilarious. Thank you for your candor and humor. Thank you, Tommy. While educating us all in the most fun way possible, while bringing us into your personal circle at the same time. Feels like we're all in the same room when I listen to your shows. Cheers, mate. We are, man. Tommy, that's such a nice comment. Thank you, brother. And thank you for being a longtime Locals member. Tommy Yofo Show in the house. Good to see you, Tommy. Really nice comment. I feel the same, my man. I really appreciate it. And I think that's a beautiful thing about what we do here is it's bi-directional. You know, I learn a lot from you. I take a lot of inspiration from your comments. I get a lot of guidance from you. I get a lot of, you know, support and reinforcement from you. So it feels like it's very symbiotic. And yeah, I'm glad you thought that was funny. You know, some people probably almost vomited at the idea, but it's pretty. How many? Do I need a raincoat or an umbrella? Sponges, tarps, what do I need? First question. Hey, NY, for seasonal allergies, X-Gel 5 milligrams, it's over the counter at the non-sedating version of Zyrtec. If you want prescription, Olopatine nasal spray. So I got, what did I get today? I think I got Allegra and Flonase. So I've been Hunter Bidening it all day in the house. So I've never really had allergies, but apparently it's a big thing here in DC. The pollen apocalypse is what they told us it was. So thank you for that, NY Renal. We're going to keep blowing the nose out, and it should hopefully clear up by tomorrow. But, you know, it is what it is. But we got business to attend to, baby. So that's why we're here. Thank you for joining us and for being here. Big thanks to our amazing mods and meme smiths who mod the fort down for us, keeping things nice and orderly. We're going to send you over. If you're on Rumble, go check out Viva. They're watching a movie right now. If you're on YouTube, stick around. We'll send you over to Jim Tells You. And we'll be back in the morning to get into it again. SB Farmer 8 says you need a slicker and a catcher's mitt. That's right. Like a net and a catcher's mitt. Like a catcher's mitt. Just, all right, baby. We got this. Ready? Let's go. Ready, set, hike. And we just get that little baby in the house. SB Farmer, thank you for that. Hilarious. Coming soon, man. Coming soon. And I don't know if my wife's listening to the show, but I love you, baby, if you are. All right. So, friends, hey, NY, Allegra doesn't work in 50% of the population. Maybe that's the problem, but some swear by it. All right. Well, maybe I'll try that's Zyzal. Non-sedating version of Zyrtec. Nice. All right. Well, we'll try that. I'm down. All right. So, friends, we'll pause here on the day. Major thanks to our awesome mods and meme smiths. Thank yous go out to Muffin Rando in the house. We got Donut Mind Me. Shout out to John is here. We got K Bean and Carrie B. Neuro D, Janek, Dog Digger, Geegum Geegum, Elliot, Just Rhonda, all modding the fort down for us, keeping things nice and orderly in the house. It has been a beautiful stream and a lovely day. And I hope that your evening is beautiful and incredible and you have the most peaceful, pleasant, and beautiful dreams you can possibly imagine. And you return here tomorrow to close out the week strong, because in order to do this appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news.